So people have millions in their, I've helped like 2,000 people set up money market funds. So wealth tribers have millions in those accounts, right? We have a portfolio of like 400 million for those wealth tribers. So then that means if you're one of those and then you pass on a year from now, please remember that your family is not going to have access to that money. That's what you're saying, that is the money market fund. So then that is why you need this to avoid, imagine the million shillings that in your money market fund, your kids having to go to court in order for them to access that money, yet school fees is due at the end of the day, right?
Exactly.
So I think you've explained it in a very, you've broken it down in a way that it doesn't feel complicated.
Yeah, right now, the Unclaimed Financial Assets Authority has 75.6 billion.
Imagine.
And they have only paid 2.56 billion. So that's money that could help so many people,
yes.
and it's just sitting with the government. And that's why what we said about estate planning. If you don't plan for your money, somebody else is going to plan it for you. And in this case, it's the unclaimed assets. And if you talk to somebody who has dealt with UFAA, it is quite a process to get that payout.
Yeah.
So don't be a statistic with the UFAA.
Yeah.
When we started at 38, Jane had a portfolio of about 8.7 million.
Yes.
So assuming now for the 5 other years that she lived, she was able to grow her portfolio to something about 15 million. Okay? With a portfolio of 15 million, if she dies having set up at the trust and having consolidated everything into her trust, so the trust fund will be accumulative sum of 15 million.
Yes.
That's a very decent capital, even assuming that nothing were to be added to that 15 million. But the instructions in her trust deed is that the trustee, assuming that she appoints her best friend Cecilia, who is financially literate and she's able to run the account, assuming she appointed Cecilia to be the trustee. So Cecilia has been left with a trust fund of 15 million. If she keeps investing this money prudently and also protecting it from risks, even with a very conservative return of 10% on 15 million, she would at least be guaranteed of receiving 1.5 million annually. When you do the 1.5 million annually, I think per month it's about 125,000 shillings.
Yeah. This year, I have helped over 200 wealth tribers to get a whole life insurance cover to protect their beneficiaries. And anytime I help someone set up a whole life insurance cover, especially parents, whether it's moms or dads, one of the frequently asked questions I get is, Agatha, what if my kids or my kids' guardian blows up the payout from the life insurance cover in a day or a week or even a month, which therefore means that this payout that I've worked so hard to buy is not going to benefit my children? How can I protect myself from that happening to the payout, to my life insurance payout? And I always, anytime somebody asks me this question, I always tell them that they need to set up either a trust fund account or a family trust. And just like you, if you may be confused about what is the difference between a trust fund account and a family trust, even I don't know, because I'm not an expert in family trusts. And that is why today I have Wamuyu and Olive on set to give us the clarity that we need. But for me, at least the one thing that I know for sure is that if you set up a trust in whichever form, it means that you will be able to use this trust to give the instructions for how the payout of your whole life insurance cover is going to be spent, or even any other savings and investments that you may have. Because when you pass on, because you're not there, you want to make sure that the things that you worked so hard for to accumulate have been used to benefit the right people, especially your children if you're a parent. And so with that, that's why I have Olive and Wamuyu on set again. They are familiar faces at this point. We have a whole series on estate planning, and family trust or trust funds is the thing that you've been asking a lot about. And so Olive, please introduce yourself, and then Wamuyu will do so.
Thank you, Agatha. Hello, Wealth Tribers. It's very good to be here again.
Karibu.
My name is Olive Wanjiku Mushoki. I am an advocate of the High Court of Kenya. I am also an estate planning and trusts practitioner. And I'm very happy to be here, and I really hope and trust that this video will be informative and helpful to our viewers. Thank you, Agatha.
Thank you. Wamuyu?
Hi, Wealth Tribers. I'm so happy to be back here. As my name, I know that this is quite a familiar face to you people. So my name is Wamuyu Kanyere. I am an advocate of the High Court of Kenya. I practice with my colleague Wanjiku at a firm called Wanjiku and Kanyere Advocates. And as Agatha has mentioned, is that we have been doing a series about estate planning, and I think she's going to link those the videos that we've already done in the description box. We've already talked about estate planning generally. We also did a video that we were talking about wills in depth. And also there's another short video about trust, but today we are going to try and get into family trust in depth. And at the end of this discussion, we hope to answer the question that Agatha has asked: what's the difference between a trust fund, a cash trust, a family trust? What do they achieve? Why should we be bothered about these things? So we really hope to have a fruitful discussion, and hopefully you will get answers to the questions you've been seeking.
Okay, yeah. So definitely this is going to be an awesome conversation, and Wamuyu is going to start us off. Demystify, what is this family trust, especially because it's become common content on our social media. You know, everyone on Instagram, TikTok, I mean, people who follow finance content, a lot of us are being advised to set up a family trust or a trust fund. So please tell us, what is this? What is a family trust or what is a trust fund account?
Okay. I think so for the majority of this discussion, we're going to talk about family trust, primarily family trust. But in the course of the discussion, of course, we'll distinguish, the difference between a family trust and trust funds, or what some people would call them cash trusts, because sometimes those terms are used interchangeably. But for the purposes of this discussion, we're going to concentrate primarily on family trusts. Now, family trusts have been quite an abstract concept to a lot of people. And I guess it also doesn't help that whenever practitioners or, advocates like us talk about these topics, they are expressed in such, again, legalese language that to many people, it's still an abstract.
Yes.
I'm going to try and simplify this as much as I can, and I'm going to use a scenario.
Okay.
And in our scenario, which is hypothetical, it's not a scenario of any given family, but in our scenario, we're going to use a lady called Jane. Jane is a 38-year-old single mom of two.
Yeah.
She has a firstborn whose name is John, who is 10 years old, and John happens to be autistic.
Yeah.
She has a secondborn who is a girl called Ashley, who is 7 years old. So Jane is a corporate woman, or she's a woman working in corporate, and she has quite a decent level of financial literacy. And so during the number of years that she's been working, she's been able to put together a portfolio of certain investments. And for the purposes of this case, we're going to say her investments are, say she has some 2 money market funds, say she has 1 long-term bond, she has some 2 special funds, which she is, funding and accumulating. She has bought a life insurance policy. She also has, she's registered with her employer's pension scheme. And of course, she has a current bank account and M-Pesa. And that's a typical portfolio for many people, say, in Kenya.
Yes.
So Jane approaches an estate planner and she expresses certain fears or certain apprehensions. And she shares with this estate planner that, look, I have this child who is 10 years old and who happens to be autistic, and I have this other child who is 7 years old. Life is not a guarantee. Anything could happen to anyone at any given point, and I am a single parent.
Yeah.
Sometimes I worry that if something happens to me, I don't know where I will leave my children. I don't know how long they would survive or they would lead a decent life with me outside the picture. And so Jane tells the estate planner that she's heard about the concept of wills, and that somebody can do a will and express their wishes.
Yeah.
But she's still not sure that even if she were to do a will and she dies when her children are still minors, and the children accesses her portfolio, because at this point her portfolio is about 8.7 million, the portfolio that we've discussed, including the payout from the life insurance.
Yes.
So she doesn't know, even if she were to do a will and somehow the children find a way of going through succession and they access her 8.7 million portfolio, she doesn't know that they'll know what to do with that portfolio. she is also worried that, you know, John is being with his autistic condition, he needs a lot of caregiving.
Yeah.
And he may not have access to opportunity to compete competitively. Even when he comes of age, he may not have access to be able to compete competitively with other people and be able to get a decent income in the long term. So these are the things that sometimes keeps her up at night.
Yeah.
So the estate planner tells her that there are certain tools in the law that are provided for, which she can use to alleviate her fears. And the estate planner introduces to Jane the concept of a family trust.
Okay.
Yeah.
Okay. So Wamuyu, let's assume you're the estate planner that Jane approached. So, and she's been introduced to the concept of a family trust. So maybe now you can explain what a family trust is in relation to Jane's situation, and how this tool is going to help Jane, you know, have peace of mind, because clearly she has a lot of apprehensions. Yes.
So when you talk about a family trust, think about a family trust as it's an entity. Think about the way you would incorporate a company and have you as Agatha, then you have a company called, say, what will your company
Agatha
be called?
Limited.
Agatha and Daughters Limited.
Yeah.
So think about a trust, a family trust, as an entity like a company. It is not exactly a company, but think about it as an entity just like a company, just that it's not regulated in the same way as a company, but it's an entity.
Yes.
So just for ease of understanding, so that it's not abstract, think about the trust as a company.
Yes.
Okay?
Yes.
So a trust is that entity which is incorporated, and the two main purposes of a family trust is, number one, the preservation of family wealth.
Yes.
The main goal why the law provides for family trust is the preservation of family wealth, and the estate and succession planning. So it is a tool that covers those two purposes: wealth management and estate planning.
Yeah.
Now, what does a trust look like? A trust will usually have three core parties. So a trust will have the person who is setting up the trust. In this case, the person setting up the trust will be Jane.
Yeah.
And the name that is given to the person setting up a trust is either founder or settlor. Either of them can
founder or
settlor.
Settlor. Okay.
Yeah, they can be used interchangeably. So the three main parties in a trust will be now the settlor. Number two, the beneficiaries. In our Jane's case, the beneficiaries will be herself.
Yeah.
Is the main beneficiary, of course.
Also,
yes.
you can be the beneficiary of your own trust.
Exactly. In fact, you should be the number one beneficiary, because why not? Because, we are talking about a living trust. This is something that you form when you're alive, and you could end up coexisting with the trust for very many years. So why shouldn't you be the number one beneficiary?
So that means I don't have to wait until I have children.
No. No. Okay. So the beneficiaries in Jane's case will be Jane herself.
Yes.
And of course her two children. If she wanted to add any of her other dependents, maybe a parent, a sibling, she could. But for the purposes of our scenario, let's say the beneficiaries to this trust will be Jane, John, and Ashley.
Yes.
Then the third party to a trust will be a person we called a trustee.
Yes.
So the trustee is the person you put in charge of the trust or the assets that you are going to put into the trust for the benefit of the beneficiaries.
Yes.
Okay?
Yeah.
So we have talked about three parties: the settlor or founder being Jane, the beneficiaries being Jane and her two children, and the trustee. Now, who can be a trustee? Number one, Jane can be her own trustee, for starter. Number one, because she's the one who has the vision of what it is that she really wants to do with her wealth and what it is that she wants to achieve for the beneficiaries.
Yes.
So she can be the trustee for starters. But of course, because we're saying a trust is also a succession planning tool, it's very, very advisable that when setting up the trust, Jane appoints a successor trustee such that, yes, this is the vision I have. I'm the one who is going to take care of it for as long as I'm alive. But if anything happens to me and I'm not there, this is the person I would want to take over my responsibilities as a trustee. So she can decide for starters that she'll be the sole trustee, or she can even find somebody she trusts to be a co-trustee. So this can be, say, a best friend who she really trusts and trust that if anything happens, she'll have the best interest of her beneficiaries.
Yes.
It can be a family member, say a sister, a parent, say a religious guide, but mostly it's friends and family. And for people who also don't have people in their circles who they feel that they can trust, we have options of corporate trustees or a professional trustee, where you engage a company to be the trustee. And of course, they come at a fee, at a little fee, but there's that option.
Yes.
So a trust is an entity comprised of three parties: the settlor or the founder, the trustee being the person who will be in charge of the trust assets for the benefit of the beneficiaries.
Yes.
So in simple terms, of course, we're going to continue breaking it down as we continue with this discussion, but think about a trust as that. A family trust is just that.
Yeah, that's very clear. My main takeaway from what you've been talking about is the fact that a lot of us, when we hear trust fund or family trust, we think that you have to be dead in order for that tool to help your beneficiaries. And now you've used a concept called a living trust. That means that even when you're alive and you have children, you can set up a trust fund, which is better when you're of good health and everything, to set up now so that you're also a beneficiary when you're living, and then when you go, it still continues to to do what it needs to do in order to protect your children. So for me, that is my biggest takeaway. Of course, we have to ask how. How do we set up this trust fund? Because usually, when we talk about trust fund, we always see the concept of trust fund babies, and we immediately conclude that that is for the rich. Me, if I'm not a Kenyatta family, right, or if I'm not a politician or somebody who comes from a very wealthy family, this is not a tool that is accessible to me. But Olive is here to tell us that, in fact, it's a process that any of us can use to set up a trust fund. So, Olive, what is the process of setting up a trust fund?
So Jane has come to us as the estate planners, and now we are having a sit down, and I'm taking her through the process.
Yes.
So Wamuyu has said about the three parties and their wishes that Jane has, such as, I want my children to be provided for, I want also to be provided for. So the first thing we do, or the first thing I would do as the estate planner, is to come up with a document called a trust deed.
Okay.
So a trust deed, think of it as a manual or a set of instructions. So whatever it is Jane wants, we sit down together and we now put it as a legal document. So the contents of a trust deed are usually, it will have the name of the trust for starters, so it will identify this trust that has been set up by Jane, possibly is called the Jane Family Trust.
Yeah.
So it will have the name of the trust. It will also document the trustees. So it will be Jane if she's a sole trustee, or if she has a co-trustee or a professional trustee, we will also indicate the trustees. It will indicate the beneficiaries. It will indicate the assets that are held by the trust. And then it will indicate now her wishes. So perhaps her wishes are, I want every month or every term, I want the trustee or John's school fees, Jane's school fees, John's medical needs, food, upkeep, to be taken out of the trust fund and to be given to the beneficiaries by the trustee. So those are some of the common features of a trust deed. And it's a very custom document because maybe Jane's wishes are different from another person. So it is not a one-size-fits-all document. We sit down, we think about what you want, and then we put it down in the legal document. So that's usually the first step. So when you hear trust deed, just think of it as a manual, a list of instructions, and it demystifies, or it puts in writing what the trust looks like. So that's the first step. So once we have, sometimes it's an ongoing process. We'll talk about it. I will draft it, send it to the trustee or to the founder. She says, okay, I don't think this will work, so let's change this. And then finally, when we have that document, the next step is now we involve the government. Now we go to a registrar called the Registrar of Documents, and then we have it registered with the Registrar of Documents. So that's the second step. Some founders leave it there, but you can continue and incorporate. So incorporation is now what Wamuyu has said, giving the trust the legal personality. It becomes a person. It becomes an entity. So that's usually the second step. Once we have the trust deed, now we proceed to the Registrar of Companies, who does the incorporation and gives us a certificate of incorporation. So if you have incorporated a company, you also get a certificate of incorporation. So it's the same. We also get now a certificate of incorporation for the trust. And this enables the trust to do anything that a person can do. So as a person, think about what you can do. You can own property. You can sue and be sued. All these things that a person can do, a trust can also do. So it can own property in its name. And yeah, that's it can open a bank account, it gets a KRA pin, all these things are usually after now we get the certificate of incorporation. So now we have our very beautiful trust. We have set it up. So think of it as you have a basket, a very beautiful basket.
Sorry, before you go to the basket, this point about incorporating a trust, you said there are people who go further and incorporate a trust. Does that mean there are people who can decide after the registration of the trust deed, that's enough for me?
Yeah, the law provides for you can just register it with the Registrar of Documents, but then that now has some limitations. So for instance, if you want your trust to have a dedicated bank account, of course you're not going to be able to open a bank account with the registered trust deed. So the incorporation gives you that legal personality. It helps the trust become a legal person. Rather than just something that has been set up and it has those limitations. It can't open a bank account, you can't get a KRA pin. So the incorporation process is usually important to give the trust a legal personality.
All right.
So now we have the trust. Let's think of it as a very beautiful basket. It's very pretty. It's empty. If you leave it empty, it doesn't do anything for you. You have a beautiful basket.
It's just a tool not helping.
It's empty. So now the estate planner tells you, let's go to the next step. And the next step is funding the trust. And that's why you hear the word trust fund, the fund. The next step is funding the trust. And funding the trust is, in very simple language, is transferring the assets that are in your name. They stop being in your name and now they become in the name of the trust fund. Let's assume this is our table. You take this one thing, you put it in the basket. You take something else from the table, you put it in the basket. So that's the process of funding the trust. And when we talk about funding of the trust, we are mentioning assets a lot. So the way you fund the trust, the assets are put in the trust in very different ways. We handle them very differently. So depending on the type of assets, we usually categorize them in three ways. They are transferable assets. There is also non-transferable but nominatable assets, and then the last category is non-transferable assets. So let's start with transferable because they are the most straightforward. Transferable assets are the ones, they usually have a document of title. So think about land. Think about shares. Think about a car. Car has a logbook. So transferable assets are the ones where you take the document of title, you go to the person who gave you that document of title, you tell them, I want this document to stop reading Agatha Wanjiku or Monica Wamuyu is the owner of this property, perhaps land. So you tell the registrar, I want this to stop reading Agatha is the owner, to now read Agatha Family Trust. is the owner
Yeah.
of this property.
Yes.
You go to NTSA for your logbook, you say, I don't want this to read Agatha, I want it to read Agatha Family Trust.
Yeah.
So those are transferable assets. They are very straightforward. Then we go to the second category. They are non-transferable, but they are nominatable. So what you do, when we mean nominatable, it means that you can't transfer them right now. You see how you will transfer land? Those ones, you can't transfer them right now, but you can say, when this thing matures, for instance, it's a life insurance, I want it to go to the trust.
Yes.
So you nominate, for instance, life insurance, I'm sure there's usually a beneficiary form.
Yes.
So you will go and update the beneficiary form to stop reading, when I die, let the payout go to this and this person. I want it to go to the trust. So we have life insurance, we have pension benefits, we have SACCO deposits, we have last expense. So the ones that usually have a nomination form, you will change the nominee, you appoint the trust as the beneficiary.
Yes, makes sense.
Now the third category of assets are the ones I called non-transferable, non-nominatable.
Okay.
So think of assets that have a personal nature to them. So think of jewelry, think of a bank account. So let's talk about Jane. Jane is employed. There's a bank account. There's perhaps a current account that is in her name that her money comes into. So that's also a non-transferable. Think of MMFs. MMFs are also non-transferable, non-nominatable. So we usually, estate planning is a matter of creativity. So you and your estate planner have to be very creative in the way you're structuring your estate plan. So for let's talk about MMFs first, because those are very common.
Yes.
MMFs, once you are dead or once you go, the financial institution in which you're holding your MMF, they will ask for a grant, which means you have to go to court. So the way we get creative as we are planning the estate, we usually tell the client, we will tell Jane, so you have an MMF with this institution. So what we are advising is go and open an account in the name of the trust, then withdraw the savings that are in your name, the investments that are in your name, you deposit them in the trust, in the account of the trust. If you already don't have an MMF, we usually advise the client, and they are hoping to get an MMF, we usually advise them, instead of opening it in your name, now that you have a trust, open the investment in the name of the trust. So that's how we deal with MMFs. Now, the other, again, I said estate planning is a matter of creativity and a matter of structuring and layering. I think even in our last video, we talked about that.
Yeah.
So these non-transferable assets, another way we deal with them is through a will that we specifically call a pour-over will.
Okay.
So think of, you're taking, the will is a companion document of the trust. So in the will, we usually say, whatever it is I have left, let's go back to our table and our basket. Whatever it is I have left in the table, if I die, I am directing the trustees to take it and put it in the trust so that it can be administered in the way I had requested in the trust. So sometimes you can set up the trust today, Agatha, it is set up, and then you die tomorrow. You haven't been able to transfer anything. So the companion will, we tell the trustees, this is what I had left, take it and put it into the trust. Perhaps you will forget something in the course of transferring.
Yeah, that's true. People forget they have a piece of land in Kamulu all the time.
Exactly. You forget something.
Something there. Even a bank account that you set up 5 years, or when you're in uni, there's an account and then it had 1,000 bob. It's still an asset.
It's still an asset.
Yeah.
There's money in your M-Pesa.
That's true.
There's jewelry or something of person. You bought a car, you bought another piece of land, or it is in the process of being completed. So you will just tell your trustees, anything I have left, and you do it in a pour-over will, anything that I have left, I want you to transfer it into the trust so that it can be administered according to the provisions of the trust deed. So the will is not going to be administered it's going to be administered according to what you had given in the trust deed. Okay. So that is how now funding the trust and the process of setting it up looks like.
Okay.
Yeah.
So clearly what you're saying is that a family trust is a customizable document.
Exactly.
Because then the number of assets I have in my portfolio is not the same number that you have. And my beneficiaries at the moment, they do not have kids, and not even assume Jane has 2 kids. It might not like be a serious thing for me right now because I don't have a kid who has autism at the moment, but in future, who knows, whatever might change, my situation might change. So at the end of the day, that the beautiful thing about a family trust, from what I get, is that it's a customizable thing. It's not a set on stone. And if you get a good estate planner, they will help you be very creative with it to avoid as less headaches as possible at the end of the day. Because I think the other thing that is important to highlight is, at the end of the day, what we are trying to solve, especially using the money market fund option, is, so for example, for the past like a year, tribers have been working very, very hard to build their 1-year emergency fund. So people have millions in their, I've had like 2,000 people set up money market funds. So tribers have millions in those accounts, right? We have a portfolio of like 400 million for those tribers. So then that means if you're one of those and then you pass on a year from now, please remember that your family is not going to have access to that money. That's what you're saying, that is the money market fund. So then that is why you need this to avoid, imagine the million shillings that in your money market fund, your kids having to go to court in order for them to access that money, yet school fees is due at the end of the day, right?
Exactly.
So I think you've explained it in a very, you've broken it down in a way that it doesn't feel complicated.
Yeah, and I'd like to chime in and just say, remember this, the trust you're setting up while you're alive.
Yes.
And Wamuyu has said you exist alongside the trust in your lifetime.
Yeah.
So the customization just doesn't end at the point of us setting it up. So you can later on in the future, maybe you had just been providing for school fees or anything or general upkeep. The children were not receiving any lump sums. And then now in the future you realize, okay, as you grow older, you realize, okay, there's something I want to change. Maybe this is not working out for me. Maybe there's something that's not going right, or there's something I want to introduce. So that existing alongside the trust helps you to keep updating or keep updating how you want your assets to be managed, how you want. It allows you to make very many changes.
Yeah.
And that's whenever we are setting up trusts and trust deeds, we will usually give the settlor a lot of power to amend, to change perhaps what their instructions were in the beginning. Maybe they're realizing it's not working out right now. So we allow them to customize and update the trust fund the trust deed as much as possible. And also to talk about what you've said, like wealth tribers have millions. Right now, the Unclaimed Financial Assets Authority has 75.6 billion.
Imagine.
And they have only paid 2.56 billion. So that's money that could help so many people.
Yes.
And it's just sitting with the government. And that's why what we said about estate planning. If you don't plan for your money, somebody else is going to plan it for you. And in this case, it's the unclaimed assets. And if you talk to somebody who has dealt with UFAA, it is quite a process to get that payout.
Yeah.
So don't be a statistic with the UFAA.
Yeah, that's a good way to close that conversation. So Wamuyu, Olive has taught us how to set up a family trust, but then there's your lady Jane, right? She had a few apprehensions. So how does the family trust that Olive has just helped us understand solve Jane's issues?
Okay. There are many ways that family trust will come in handy to assist Jane, both Jane and her children.
Yeah.
Number one, there are many scenarios could play out, okay? We started with Jane when she was 38.
Yes.
She could die 5 years later.
Yes.
Okay?
Yeah.
If she dies 5 years later, she'll die at 43. If she dies, now that's what we'll call a premature death in that situation. It will be a premature death. She dies at 43. And so her children will have been left. John would have been left at 15 years. And Ashley will have been left at 12 years. For all intents and purposes, these are still children.
Yes.
These are still kids.
Yes.
So number one, there'll be the question of who takes over the caregiving or taking care of the children.
Yeah.
The trust, alongside the will, would have assisted Jane to appoint a guardian such that she doesn't leave that job to just anybody who wishes to, or her kids are being kicked from one home to the other. Oh, mimi nimekaa nao 3 months, but hata wewe kaa nao 2 months.
Yeah.
Number one, Jane will have made a decision that this is the person I would want to entrust for the purposes of raising my kids when I'm not there.
Yes.
But she also won't leave that person empty-handed, because what makes the burden of caregiving so hard is the financial burden that comes with it. Say I could have a sister and my sister passes on, and I'm very happy to take her children in.
But if you don't have money,
whatever income I'm making is barely enough for me and children, my children.
Yeah.
If I were to take on 2 extra children into my household without any financial support that comes with it, that's now where the complications comes in. Now that's where now you find kids being moved from one home to another. There's at some point they might end up in foster care or at the streets. So number one, that will have helped Jane set up a structure for who will take care of the children and how the children will be taken care of. So that's an appointment of a guardian.
Yeah.
Number two, assuming that when we started at 38, Jane had a portfolio of about 8.7 million.
Yes.
So assuming now for the 5 other years that she lived, she was able to grow her portfolio to something about 15 million. Okay. With a portfolio of 15 million, if she dies having set up at the trust and having consolidated everything into her trust, so the trust fund will be accumulative. Will be accumulative sum of 15 million.
Yes.
That's a very decent capital, even assuming that nothing were to be added to that 15 million. But the instructions in her trust deed is that the trustee, assuming that she appoints her best friend Cecilia, who is financially literate and she's able to run the account, assuming she appointed Cecilia to be the trustee. So Cecilia has been left with a trust fund of 15 million. If she keeps investing this money prudently and also protecting it from risks, even with a very conservative return of 10% on 15 million, she would at least be guaranteed of receiving 1.5 million annually. When you do the 1.5 million annually, I think per month it's about 125,000 shillings.
Yeah.
So whoever will be the guardian for these children will be assured that at the end of every month, I can be guaranteed that I'll receive at least 125,000 shillings to support the children.
Yeah.
Honestly speaking, 125,000 is decent money to pay school fees in decent schools.
Yeah.
And to provide basic life needs, food, shelter, clothing. It's an income that the 2 children can manage on for a very long period of time.
Yes.
So one way that now the trust could have been structured to take care of that, such that whoever now is left taking care of the children now is guaranteed of a very long, because the 15 million could keep getting reinvested and reinvested for years and years on end, and could even grow, assuming that the financial markets perform even better and maybe the average return is say 14 net. It's a really decent income that can continue sustaining these 2 children for a very long period of time. And the trust deed can even go ahead and say, when these children achieve, say Ashley, who is able to maybe continue through school and maybe even go to tertiary educate, get a degree. And so the trust deed can go ahead and even say that when Ashley gets her first degree or attains the age of 25, give her a lump sum of this amount of money to set herself up. So we can say divide this 15 million into 2 and give a lump sum of, is it 7.5 million? Give Ashley a lump sum of 7.5 million when she is 25, or if the 15 million will have grown, then that amount of course will be higher, and let her set herself up. So if Ashley wants to start a business, she has a starting capital.
Yeah.
If Ashley is maybe employed, she can invest this 7.5 million and have some sort of passive income to shield her through the tough months. So Ashley wouldn't be starting at zero. On the other hand, the amount that is left and continues to be invested, the trustee can continue now providing a monthly stipend for now John's needs. If he is not able to, you know, get gainful employment later in the future, at least he'll be assured that at the very least there's money to pay for his caregiver, there's money to pay for if maybe he needs some therapy sessions or anything, there's money for that. And that is something that can sustain those two children for a very long period of time. So that's just one of the many benefits that Jane and her children will have benefited from the trust. Number two, because by setting up the trust, you avoid, no, we are not going to go into these details because we already spoke about them in our previous videos, that trust, whenever you set up a trust and you move your assets into the trust, those assets are exempt from probate. So they didn't need to go to court unless there was something left in the power over will that will necessitate them to go to court. At least a majority of the funds will be immediately accessible. So there will not be a case of John and Ashley looking for a lawyer and being dragged from court to court for years, being told, go get a letter from this chief or pay the chief pesa ya chai, and going round and round in circles and paying a lot of legal fees and moving from one court session to another until they get, succession papers. And then after succession papers, now they start tracing where were our mother's investment. Maybe Jane had bought a bond a long time ago and nobody knew about it. Then the bond matures, it's paid into her account, and because nobody knows her account number, nobody knows the PIN, 2 years lapse, nobody is claiming the money. The money is sent to UFF, the Unclaimed Financial Assets Authority. Now the children, or whoever the guardian for the children will be, won't have now the responsibility of now following up all those processes. They'll literally be able to access the funds immediately and use the funds for a very long period of time. So those are just one of the few ways. And of course, there are a lot more benefits, even privacy. Having set up a trust fund, family trust, and because a family trust is a very private document. It's literally between the settlor or the founder and the estate planner and the trustee. So nobody needs to know what Jane's arrangement was. Nobody needs to know what is happening with Jane's affair. So the children will still be able to live a very dignified life, even in Jane's absence. So those are just some of the benefits that would alleviate Jane's apprehension.
Did you talk about what if Jane lives a long life? Like, what if she gets to live a long life at the end of the day and her kids are now adults? How would that play out?
Okay. Again, we said if she died at 33, that would have been the unfortunate premature death.
Yes.
Nothing would have stopped. There's nothing to say that she couldn't have lived the entire, an entire couple of years, and maybe she dies at 70. Now, if she lives along and dies at 70, her children would have been maybe 42 years. John would have been 42 years by the time she's passing on, and Ashley would be maybe 39, probably even having a family of her own and children of her own. Again, from that net value of 8.7 million that she had at 38, by the time she's 70, she's grown it over and over and over. And maybe by the time she's dying at 70, her net worth is like, say, 50 million. Now, the trust will continue. Of course, now as long for when she's living, Olive mentioned that as circumstances change, settlors and founders can always revise their trust to cater for arising circumstances. So she can, one of the ways that can play out is that if the trust fund didn't cover Jane, say the children, her children's children as beneficiary, she can always revise it along the way and say, now because my Ashley has children, why not include two of Ashley's Ashley's two children into the trust? And because now the trust has a very decent
amount
fund, why would Ashley be struggling to pay school fees when there's this trust fund? So that's how literally Jane can create generational wealth, because then these 50 million may not be exhausted by John and Ashley during their lifetime, because assuming even Ashley also has a decent income of her own. So literally what they'll do is they'll be pulling these funds, and these funds will keep getting growing. And what will happen is that both John and Ashley their children, their children's children could all later benefit from this wealth. And now that's how generational wealth will get created. Because as long as this 50 million is well managed, it can go run down the generations for a very long period of time, just being reinvested, growing, of course, dispensing whenever there is need, accumulating. That's how generational wealth will be created. That's how Jane will have created her legacy.
Yeah.
At the very least, she created generational wealth for her entire generation.
Yeah.
And it can go on for years and years and years. And there's been people who've managed to do this. We're not just talking about a hypothetical.
It looks like a hypothetical.
Yes. And I can give an example of this politician, Jenga Karume.
Yeah.
Jenga Karume is one of the people that tapped into the power of a trust very early on, even before the law on trust was very streamlined. Right now, we have a very good law on trust. Back then, it was quite scattered. The law, the rules were quite scattered. It wasn't very clear how this trust thing would run.
Yeah.
But in as much as it was like that, Jenga Karume found a way of using trust to work. And I think he left a net worth of about 40 billion was it 40 billion? I think 40 billion at the time he was dying. And he set up a trust. And that trust, years later, continues providing for his generation.
Yeah.
Years later.
Yeah.
It has, along the way, it has had issues. At some point, the trust was in court to try and change the trustees who weren't really managing the trust well, and they were replaced. But even with the challenges, that trust has continued to provide for his family years and years on. So right now, to his grandchildren, Guka wasn't just Guka.
Yeah.
Guka set us up.
Yeah. And I think that is what we mean when you say leave a legacy.
Yeah. So
like you will know he existed just because of what he did when he was here, right? That's very powerful.
Yeah.
Okay, so thank God you've painted both scenarios for premature death, which is something parents fear, and instead of fearing, set up the tools that you need in order for you to protect your children. Then you've set up, all of us pray for a long life, and you've told us what would happen if you live a very long life. So that's awesome. But earlier on, you mentioned that Jane has a friend called Cecilia, and Cecilia is the one who was nominated to be the trustee of Jane's family trust. So Olive, my question is, what would prevent Cecilia from misappropriating the 15 million, the money? Is there a law that makes sure that at the end of the day, even if I have this tool, because people are people, like, humans are humans. I've seen, I was telling my friend the other day that I've seen someone who got a life insurance cover, passed on, left the money to the brother to take care of the children. The brother got on a plane and went to Dubai for 6 months, 7-star restaurants, yachts, and girls. And he came back, the payout was 30 million. He came out back with 300K in his account. It's things that happen in this country. Yeah. So what would prevent Cecilia from blowing up the family trust fund?
So I will answer that question with 3 answers. So let's start with the first one is, when I was talking about the process of setting up the trust, we talked about the trust deed. And when we are drafting trust deeds, we usually put safeguards within the trust deed. Nice. So one of the ways we do that is requiring for trustees to account, to provide accounts and audits. Sometimes we even say the trustee has to make sure that the account, the trust fund and the accounts of the trust are audited annually. We also provide for the trustees to give reports to beneficiaries. So supposing in the example of John and Ashley, perhaps they're adults now.
Yeah.
So one of the ways we'll say is that as a trustee, you have to report to the beneficiary. If you supposing Jane did not appoint Cecilia as the guardian, or there's another guardian, the guardian of the beneficiary we can allow for the guardian of the beneficiary to receive a report from the trustee on how the beneficiaries are being provided for.
Okay.
So there are safeguards we will put in the trust deed itself. We can even, another safeguard, we can even say that after Jane passes and the successor trustee takes over Cecilia, we mandate for Cecilia to appoint a co-trustee.
Okay.
Or 2 other trustees. It is very difficult to for three people for one it's very easy for one person to do whatever they want, but if there's three of you or more of you, one person or two people can be able to act as a safeguard. And one of the ways Cecilia won't just appoint anybody. Sometimes in the trust deed we even put an eligibility criteria for a trustee. So we say, if perhaps I left Cecilia and she has financial literacy, we tell in the trust deed, I say, when I pass on and the Cecilia takes over, this is the criteria you have to follow to appoint a trustee. So you just don't go and pick somebody in the village. You have to figure out, does this person, so in one of the ways we say, if the founder wants that her trust to be managed by people who have a master's degree in a certain area, or they want a trustee who is above a certain age, you can even say, my trust should only have trustees who are over 30. You can even indicate that the trust should always have a descendant of me. The board of the trustees at all times, there should always be my descendant, because if there is your descendant, perhaps there will be more, you can be able to pass on the vision to them as the founder. So that is one way we include safeguards in the trustees, in the trust deed. The second way is the law on trust now provides for a very special office called the enforcer, or a protector. In other jurisdictions, they are called protectors of the trust. So an enforcer, we talked about our beautiful basket. We talked about, think of it even as a safe, where the trust is your safe and it has your assets. The enforcer is like a CCTV camera.
That's a good one.
Or a security guard. They stand there and they watch over the trust fund. So they are watchdogs of the trustees. So the trustees can't just do whatever they want. There's someone who is watching over them and they are monitoring what they are doing. So for instance, an enforcer can require that annually, as a trustee, Cecilia, you have to give me a report of what you have done with the trust fund. An enforcer can hear from the beneficiaries, or a guardian of the beneficiaries, supposing your friend, what you are talking about. An enforcer can be able to hear from a beneficiary, and the beneficiary can be like, okay, my school fees has not been paid. And then the enforcer can summon the trustee, let me know, why is this not happening? The founder can give as many powers to the enforcer as possible. You can even give your enforcer the power to veto trustees' decisions. The trustees make this decision and the enforcer is like, no, this is not going to work out. So don't do that, do this. Or you can even give your enforcer the power to remove a trustee and appoint another trustee. So, and you can even give your enforcer the power to recommend to the trustee, please amend this part of the trust deed, it's not working out. And another very good power of an enforcer is they can institute a court case on behalf of the beneficiaries. So if they have tried to work with the trustees are not following what they want, the enforcer can now say, okay, now we are going to court and let the court decide, remove these trustees, let's start again. Or they need guidance on anything, so they can always go to court on behalf of the beneficiaries. So as we think about an enforcer, let us remember that the enforcer is your watchdog, the enforcer is your referee, the enforcer is your security guard. So they watch over what Cecilia is doing. So that's a second way. Then a third way that we recommend also is a corporate trustee, as Wamuyu mentioned, or a professional trustee. There's a lot of professionalism in how they carry out their roles. They have, reputation. They will try and protect your reputation. So, and for a corporate trustee, there isn't, what is the word? There isn't that personal attachment.
They have no interest in stealing your money.
Exactly. Compared to a person who a person can get tempted. Exactly. So those are three ways in which we introduce safeguards to prevent the trustee from misappropriating funds.
Just to be clear, is this enforcer the government or some?
Oh no, sorry. I let me clarify that. An enforcer, in most situations and most times, is usually a lawyer. And specifically, it is better that your enforcer is the lawyer who set up your trust. Or if you have a personal lawyer, sometimes your estate planner is not going to be your family lawyer. So an enforcer is anybody, but we usually recommend lawyers because we understand the law on trust. We can even be able to institute a court case quicker than any other person. So in most instances, in most family trusts, the enforcer is usually a lawyer. The lawyer either the lawyer who helped you set up the trust, or if you have a personal lawyer or a family lawyer, they can also be your enforcer. But you can pick anybody else. You can decide, let me pick an accountant, or you can even pick a parent.
Yeah, but that's a lot of work.
That is going to be a lot of work, and they are limited in some ways.
Yes,
but you can pick anybody. We just usually recommend lawyers. And to add on the parts on safeguarding the trust from misappropriation, I would also like to bring in the point of courts.
Yes.
Our courts are very instrumental in enforcing the wishes of our settlor. So if we have gone through all these options and we have not been able to maybe tame the trustees, there's always the option of courts. And sometimes the law in some the acts, the laws on trustees and trust funds, they provide for. Sometimes the trustees don't even know how to deal with the property. So you can even seek guidance from court. It doesn't have to be a dispute. You can even, as trustees, perhaps Cecilia or whoever Jane has left is having a problem to trying to figure out how do I deal with this property. So you can always apply to court for guidance. And even if there's no enforcer and they're adults, so like in the Jenga Karume case that Wamuyu brought up, the people who went to court were the adult beneficiaries. They went to court and they asked the court, the trustees are not doing what they were supposed to do. And the court actually removed the trustees, recommended that the trustees be removed. And not only that, they asked that the trustees account for what they had been doing with the trust fund.
Okay.
And also, I think some of the trustees were found personally liable for the misappropriation of the trust funds.
Okay.
So our courts are very helpful in resolving disputes that might happen in the course of the administration of the trust when you're gone. And sometimes even if the beneficiaries left are minors, sometimes even the guardians of the beneficiaries can also approach courts for resolution.
Yeah.
So there are very many ways of safeguarding the trust. It just needs to be structured in a very good way, and that is where your estate planner will come in. Again, estate planning is a very creative, very hands-on, very customizable process.
Yeah. I'd rather have that problem of approaching the court to give guidance of how my money will be spent as opposed to my children not having school fees, based on.
Yeah, and maybe also just to add on to this discussion, you see this scenario we're using of Jane being a single parent of these 3 children at their age. That's just like one of the many scenarios where a family trust would work. We just use that being a very simple family with a very simple trust, just to make this information digestible, or just to make this conversation comprehensive to many people.
Yeah.
But of course, there can be very many dynamics, very many complex family situations. So we could even have, say, a different scenario would be the people setting up the trust. In this case, it's not Jane. Say it's a couple and they have children. They set up the trust. They move their assets or the assets that they have acquired together into the name of the trust. And of course, the beneficiaries in that trust will be, of course, the two parents and their children. Now, one way that could play out is that a couple of years down the line, these people could go their separate ways and divorce. What would happen to what had been put into the trust account? One way of going about it, and it's actually one of the advantages of trust, a trust can be very instrumental in solving matrimonial disputes. And this is how one way that it can play out. Number one, if at the time when the couple was setting up the trust, of course, the workout deal, everything was for the best interest of everybody. Nobody was trying to be malicious. Nobody was trying to be vengeful, which happens a lot at the time of divorce. People now have there's a lot of animosity.
Yeah.
So at the time of setting the trust, of course, most of the terms that went into the trust deed were for the benefit of everybody mutually, both the spouses and the children. So one of the ways that a trust can resolve that matrimonial dispute is deciding at the time of setting the trust, is say they have a family home or a matrimonial home. They decide this home, we are going to move it into the trust. And no matter what happens between us as a couple, this particular asset is going to be maintained into the trust for the benefit of our children.
Okay.
So the arrangement can be, if we have this home, say a good home that has been built, a 4-bedroom house, we decide that if we go our separate ways, instead of now starting to sell off these assets and then trying to divide these assets in according to, I don't know, a contribution or 50-50, then but maybe one person doesn't use the proceeds of the money to do something meaningful for their lives, and at the end of the day, the person who suffers are the children. They decide that this home, we're going to maintain it as a unit, and whoever it is that gets primary custody of the children is going to be the one living into this house, in this house. And of course, there, the goal is for the benefit of the children. So the children still end up getting a home. If you go your separate ways, so of course the spouse that lives will find a different residence, but this particular house will be left for the benefit of the children. So instead of the way now it would have been sold and then the money is divided but eventually doesn't benefit anyone, the trust has helped resolve that issue very well. And can even be decided that assuming even in another scenario, it's that yes, the couple set up a trust as a couple and they have children. Several years down the line, say one of them dies, say the woman dies, and maybe one of the apprehensions that this lady had before she died is that, what if I die and this man remarries, and now the new wife that comes in and the children that they get start now benefiting from what I worked hard for, and sometimes it's at the expense of my own children. So it can go into so one of the ways of avoiding such situations will be some of the rules in the trust being very clear that the assets that we have mutually put into this trust is specifically for the benefits of our blood children, without excluding stepchildren, step relatives, such that if another child comes maybe with another spouse, then that child would need to be provided for separately with the spouse that has, say, sired that child. So a family trust can, when used creatively, of course, as Olive's saying, is a very creative tool that can be used to solve very, very many scenarios, such that people are not battling heads every day in courts trying to fight over and traumatizing children in the process. Whereas there's a tool that they could have used from the very beginning when they were cordial to, for the mutual benefit of both spouses and children. And again, this scenario of Jane was, again, a very simple trust that doesn't have, say, businesses. So there are families that will have a bit more complex dynamics, such that maybe they have family businesses running. And because essentially a family trust is not a trading entity, so you can't open, say, a supermarket using your trust. The supermarket is the Agatha Trust supermarket. You can't. So for the purposes of trading, the law makes it mandatory that you have to register company. Either you trade with your own name or you register a company or an LLP, whatever vehicle you decide to use. And one way of now incorporating that company or trading entity with the family trust, such that whatever benefits or whatever profits are derived from that company flows into the trust, is ensuring that you set up the company that is trading, but ensure that the shares of that company are owned by the trust, such that the company does the trading, it files its return, whatever profits is made is now paid into the trust as dividends.
And kids get to benefit.
Yes. So there's a lot of structuring that can happen just to ensure that at the end of the day, everything that you want to be collected in the family trust fund pool can still happen.
I like that, especially that example of a company, because I assumed that when she said that you've incorporated, so now I can open a business.
No, specifically trading, family trust is not allowed to trade, but you can now take the trading company family trust, but ensuring that the shares are owned by the trust, but the company is the front The front side is the one that running the business.
Yeah, because we've seen a lot of families where the person who's passed on was actually running a very profitable business or a very big business, but you guys who've been left are not even benefiting from the proceeds of the business, which then a family trust solves that problem.
To add on family companies, for a long time, family companies have been used as a tool of estate planning and preservation of wealth.
Yeah.
But family companies usually have one limitation, is that at the point of the shareholders passing on, perhaps let's say Jane had a company in her name, when she passes on, and even if perhaps she had not even left the will, company shares always go through probate.
Okay.
They always go through probate.
Yeah.
They have to go there. If we want to transfer the shares from your estate, perhaps your children, you have to go to court, get the grant, submit the grant to the Registrar of Companies, and now the Registrar of Companies does the transfer from the estate to whoever you wanted to inherit those shares. So that's a process, of course. But if the trust owns the shares in the company will just continue to trade. If Jane goes, there isn't the transfer, because the trust is an entity that continues to exist even after the person has gone. So this pausing of trading that will usually happen as you're going to court to transfer shares, perhaps the directors are fighting. That process is bypassed by a trust, because then the family business continues as is, and then the profits go to the trust, so there's no that pause. So we are really dissuading people from using family companies as a tool of succession. Because if probate court is involved, then of course there's going to be issues, and even where there are no issues, there's the time factor.
Time factor. Exactly. Imagine pausing trading so that we go to court. Of course, wow. I don't know why that has excited me so much. I think it's something that a lot of us do not think about. We only think about when there's a scandal on TV about, who was left what. So that's very beautiful. So timelines. You taught us the process of setting up a trust fund. Usually, how long does it take?
Nowadays, because the process has been moved to the Register of Companies, the longest time or the most time is usually spent between me, the estate planner, and the founder, us discussing the trust deed. So depending on the complexity, it might take a bit of time, but the process of registration has really been simplified. It is online, so it takes we are doing it online through eCitizen actually. So because now it has moved to the Register of Companies. So the first step, the Register of Documents, that usually takes a short time, between 1 week to 2 weeks, and then the incorporation process, it can take 1 month minimum, or sometimes it can go to 1.5 months. So if we start today, I can assure anyone who's listening that within 2 months, the whole thing is set up. And we are really hoping that the Register of Companies continues with the proactiveness that they have right now, so that the timelines keep being at that, because in the past, it used to take a really long time, even 1 year, 2 years. But now, because the process has really been simplified with the Register of Companies, within 2 months, within 3 months, you can have your family trust ready. Now
that you've mentioned that the incorporation was moved to eCitizen, does that mean you can also help tribers in the diaspora set up the...
Exactly.
So you don't have to be physically...
you don't have to be physically here. The only thing we will need to do is perhaps courier the documents for you, the trust deed, because we need them to be signed with wet ink. And we are hoping with time the Register of Documents is going to start accepting electronic signatures. But that's where we are right now. But the entire process, the online process, and also because you mentioned diaspora, I think maybe some wealth tribers are asking, perhaps I am in the diaspora, I am married to, maybe my wife is a foreigner, maybe my husband is a foreigner, can we both be founders, or is it me who is a Kenyan only? And I can assure them that even foreigners can be settlers or founders or trustees of trusts in Kenya. So you don't need to be a Kenyan. If you have property in Kenya, or if you have beneficiaries in Kenya, sure thing, you can be a founder.
You need to set up the process. I like that addition. And so, Wamuyu, online or of late, we've seen this corporate trustees talk about the concept of setting up a trust fund, and they've simplified in such a way that it seems like you can even set it up online yourself. Go online, set up your trust fund account, and within the same way you set up a money market fund online, within 5 minutes you have your trust fund account, or your cash trust as you called it. So what is the difference between a trust fund or a cash trust and a family trust, so that we know where are we supposed to go? Are we supposed to come to you lawyers for the complicated solution, or can we just trust a corporate trustee to set up this thing for us in like 5 minutes?
Okay. Now, there's distinction between the two, and maybe the challenge that we get sometimes is that those words can be used very interchangeably.
Yeah.
Now, for the purposes of making it very clear, the whole conversation that we've been having is specifically for family trust.
Okay.
Again, there are many types of trusts,
Yeah.
even leave alone the trust funds or the cash trust. There are other trusts that are recognized in law. We have charitable trust, the ones where you set up a trust and the main purpose of that trust is funding charitable purposes. So it could be you're funding children's home, or you're funding environmental causes, or whatever it is. Then there's another form of trust called special purpose trust. So those are trusts that can be formed for a special purpose. So you can set up a trust and you say, this trust, I'm funding it specifically to fund, maybe to fund a certain party during the 2027 general elections.
Yeah.
They are allowed in law, and the whole purpose of that trust is to fund that particular cause. Such that the moment that cause is done, then the trust ceases to exist. So under the law now, there are those three recognized trusts. The family trust, which is for preservation of family wealth and succession planning.
Yeah.
The charitable trust that are for charitable purposes, and the special purpose trust for whatever special purpose it is.
Yeah.
Now, when it comes to corporates, and mostly these are asset managers or insurance companies, they've been offering a product they call, let's call it a cash trust, but sometimes it's interchangeably used. They interchangeably use the word trust fund.
Yes.
But I think trust fund is more appropriate for the funds that are in a family trust. Such that now, once you move the assets into the family trust, now that's what becomes the trust fund.
Yeah.
But so for the purposes of the product that is being offered by the asset managers or the insurance companies, let's call it cash trust.
Yeah.
So this cash trust, it's an account, and it's not a private account. Again, that's the number one distinction. That one, the family trust is a private entity. It's just me, or in our case, Jane, approaching the estate planner to set up the Jane Family Trust. A very private entity. The trust deeds that they come up with is a very private document and everything. This other one that is offered by the asset managers, it belongs to them. Think about it as a collective, you know, the way there's MMF.
Yeah.
It's owned, it's sort of, they're the custodian.
Yes.
So in this case, so they offer the cash trust, and the cash trust can be used to administer certain assets, specifically cash and cash equivalents.
Yeah.
Now, the ones that I know currently, cash trusts are able to handle this cash, such that you can open an account and you have a lump sum and you deposit into that account, and you give them instructions that if I die, this is the way I want you as the custodians to distribute these amounts. So there's cash. You can nominate those cash assets as the beneficiaries of a life insurance, or retirement benefits.
Yeah.
Also, there's a way they can be structured to handle things like bonds and special funds, but they have certain limitations. And the limitations that those cash assets have, number one, they can't handle assets such as stocks. They do not have the capacity to handle assets such as stock. And they also do not have capacity to handle assets such as real estate. So if you have a piece of property anywhere or an apartment, the cash assets usually don't have the capacity to handle those kinds of assets. Number two, what distinguishes the family trust from the cash trust is flexibility and autonomy. Again, as you said, the family trust is a private entity. You literally set down the rules. This is what I want you to do with my money. This is where I want you to invest it. This is how I want you to distribute it. There's a lot of autonomy and flexibility that you can work with them that the cash trust do not allow you. A lot of the decisions with the cash trust will be made by the trustee and the asset manager. So Those are the two major distinctions. The fact that this one is a private entity, and there's autonomy and flexibility with the way you can run it, and then it can handle all kinds of assets. There's no asset that cannot be handled within the family trust, but the cash trust have certain limitations of assets they can handle, and then also there are decisions where the SEC law or whoever is setting up the cash trust doesn't have autonomy to make such a certain decision. So that's the best I can explain it as now.
It makes sense.
Yeah.
It makes sense to me. What you mean is that, yes, you can set up the simple one, and it can handle, like a money market fund and bonds, and you can deposit cash into it. But honestly, the average person, that is not the only thing they have as assets. The average person has, a car, a piece of land, like every other Kenyan. And so if you do not customize your family trust, or if you do not customize your trust, then it means you're still leaving your people vulnerable.
Yes.
I feel that I've gotten the clarity I needed, especially distinguishing. Now I will advise my life insurance clients better about whether they should set up a cash trust or set up a complicated or whatever level of a family trust. And so with that, personally, I've learned a lot in this session, and we've been looking forward to having this conversation. So asanteni sana once again for always educating us. Yeah. And as always, if we want to consult you for everything that we've talked about in this session, where can we find you?
We can be reached directly on ourselves. So for me, you can reach me at, my number is 0716 523 959, and I'm sure you will link it.
Yes, I'll write it on the screen.
And then you can also email me on my email, wanjiku@wanjikukanyiri.com. Or you can email our email is our company email at info@wanjikukanyiri.com.
Okay.
I think Wamuyu will say her contacts.
Yes, you can also reach me on my line, which is 0715 934413. 0715 934413. Can make a call, or it's also accessible on WhatsApp. Again, my email is wamoyo@wanjikukanyiri.com. wamoyo@wanjikukanyiri.com. Of course, the alternative is the one that Olive has given, info@wanjikukanyiri.com. And if you want to give us a physical visit, we have an office at town in a building called View Park Towers, 8th floor, Transcon office suites. So you're welcome.
Asanteni sana. All right. And as always, my name is Agatha from the Wealth Tribe, and this is where we learn how to build wealth together.